As I announced already quite a few times, this is a first in the history of this conference cycle. First time that we welcome on the very same panel competition agencies, practitioners, and someone working for a company. Once again, we don't have any business relationship with any of those entities, so we've invited them because they have great expertise. So I can't wait for this panel, and then I will do a conclusion in about 10 minutes. We'll see what I can pull out in the meantime. And I'll give the floor to Maria, who is one of our great editors. So Maria, the floor is yours.
Thank you, Thibault. I hope you're listening to me properly. Okay, so hello, everyone. I see everyone. I think I'm missing Sophia. I'm just gonna move on. So hello, everyone. I am Maria Manuela Palacio. I am a Colombian lawyer, currently JSD candidate at Stanford Law School and member of the Computational Antitrust Project. First thing I want to say is that we're so thankful and lucky to have all of you speak at this conference. Thank you for taking the time to prepare your remarks and be here today. Thank you for agreeing to share your experience and for educating curious people who want to learn from you. Second thing I will say is that this is a project and a conference that has been reaching a lot of people from across the world who are eager to contribute to the project of improving how markets and competition works, and particularly who want to actively contribute to the project of improving antitrust by innovating and being creative and being very forward-looking. And one way to do that is by implementing computational tools and developments into legal and economic analysis. So wherever they are in the world and whatever role they are occupying, whether they are part of the government, in a law firm, in a corporation, advocacy group, or in academia, the people this conference is reaching are already using computational tools as part of their job, or will be analyzing the implications of their use for decision-making or shaping markets, market dynamics, or will be even designing these tools themselves, as we saw earlier. So I am saying this because I would like the panelists to keep this in mind, to know that to flourish, this field requires a lot of effort in translating complex knowledge from one discipline to another. Please share with the audience those insights and experiences that you believe are fundamental to understanding what we mean by computational antitrust. How does it look in practice? How are computational tools and methods integrated in antitrust analysis and related procedures? What have you learned from those processes of integration, and what you ask others in a similar path to keep in mind? What have you realized about what these tools can actually do and what they cannot do, and why? How are these tools beneficial and how they are improving the efficiency or the accuracy of antitrust analysis? Or maybe how they are complementing other types of analysis in antitrust. And of course, we would like you to share with us what you see as limitations and how these have been addressed, or how would you suggest they should be addressed. In answering to these questions, I would like the speakers to provide us with as much real and practical information as possible, information that we as audience can go back in the future and try to incorporate in our own work as learnings, and also that we can fully grasp how computational antitrust works in practice and what are the challenges we need to work on. The purpose of this call, and the reason I am taking a lot of time doing this, is to encourage you speakers and all of us participating in this conference to help with the understanding of computational logic and its practical application, so that in a way we can demystify it and then increase research, development, and adoption of these good tools across jurisdictions. So having said that, our speakers for this panel are terrific. When you read about their work, you can only be inspired and really curious about their exciting experience and what they have to say. For now, let me introduce them briefly and move on to the discussion. First, we have Winnie Ching. She's legal director at the Competition and Consumer Commission of Singapore. She's responsible for reviewing decisions, supervising investigations, assessing mergers, and providing advice on legal and policy matters. Christina Nordlander is partner at Allen & Overy, a leading EU antitrust litigation and regulatory practice with a particular focus on big tech and life sciences. She's founder of and runs Women's Competition Network, which is awesome. We have Asimakis Komninos. He's his partner at White & Case. His practice focuses on complex cases of abuse of dominance, restrictive agreements, and merger control reviews. and on newly adopted Digital Markets Act and Digital Services Act. He represents clients before European courts, European Commission, national competition authorities, national courts, and international arbitration tribunals, which is also amazing. And we have Sofia Real. She's a senior competition counsel at Google. As a senior counsel in Google EMEA competition law team, she provides strategic advice to global business on all aspects of EU competition law, with a particular focus on the ACH region. So I am delighted to welcome our speakers. I'll divide the discussion in 4 blocks. First, a general question to all, and then I'll direct questions to each of you and ask for comments from the rest. So let's start by asking the entire panel about a fundamental question, the meaning of computational antitrust. So I like to start this panel or discussions in general, always by testing assumptions on what we think we know and what we think that everyone knows. We are assuming that we all know what computational antitrust means, but I am curious as to how each of you are using the concept computational antitrust in your practice, and how has the use of this concept changed with time, and the more you update your knowledge and the more information we have available. So also, I'm curious to know, how are you learning and updating your knowledge on computational antitrust? So Christina, can you go first, please? Then Winnie, Sofia, and Asimakis. You each have more or less 5 minutes. Thank you.
Absolutely. Can everyone hear me? Yes. So Maria, thank you for that brilliant introduction, and especially the shout out to the Women's Network, which I like. And it's a pleasure to be here and to be invited. This is a brilliant initiative. Very much in favor of new thinking and being innovative to serve our clients. So very, very happy to be part of this discussion. I have to admit, the concept was kind of new to me. I mean, having now taken a dive into it, I realize, of course, that what we're talking about is not new to me. I mean, I see it all around me and have some experiences that I'll share. But the actual concept, which is why I suggested we start with that question on the panel, because I wasn't honestly sure exactly what was meant by computational antitrust. And maybe I'll kick off my answer. I had the pleasure of listening in on some of the discussions today and yesterday. And Susan Athey, of course, gave a brilliant keynote yesterday. The chief economist of the DOJ, who's a computer scientist, if I'm not mistaken. She said that a lot of what we're talking about is kind of conceptually doing the same old thing we've all been doing for a long time, but just using new tools and software to implement, what we're doing, because we're just dealing with enormous data sets. And I think, I don't know if others agree, but I think that's one way of looking at it. How are we using software and tech to kind of do a lot of things that we've always done, i.e., detect cartels, defend against cartel allegations, do large doc review, et cetera, but dealing with huge data sets and using machine learning and maybe automated decision-making tools to do that. So that's one way, I think, of maybe looking at the concepts. And I won't spend too long, but just looking a bit at what was discussed in previous panels and what I read in some of your brilliant kind of publications, I just note that we're talking about a huge set of different things, which is, can be interesting for our discussion. I mean, just a few examples that I've heard and picked up. I mean, a lot of it, I think, has to do with cartel detection and bid rigging detection, maybe in particular. I mean, there's some interesting projects by agencies to kind of collect data from local and central systems, and again, deal with large data sets to detect patterns in bids, which I think is interesting. There was something, I think this was Chile, where they look at concentration threshold, notification compliance, and cross shareholdings and potential gun jumping issues through automated tools, which I also thought was very interesting. The UK CMA in its report talks about machine learning to review documents and evidence, translation, which is kind of a fairly simple thing, but important. And of course, using as part of its merger intelligence unit, these kinds of tools to look at, potential mergers of concern that they want to pick up. So, a lot of different things. I've also seen ideas where you use, automated tools to look at, how do we interpret language concepts in the DMA, for example. You know, what do we mean by self-preferencing? What do we mean by different concepts? Are they used differently in different places? I thought that was quite interesting. So anyway, I'll maybe leave it there, but it's, you know, I think it's a lot of new tools, sophisticated tools to deal with large data sets, but in the end doing a lot of, you know, again, conceptually the same things as we've always been doing in antitrust. And it seems to potentially mean a lot of different things. So I don't know if anyone has a more kind of defined, clear definition of what computational antitrust means, but that would be my comments to kick off the discussion.
Well, let me echo the similar thoughts in relation to my understanding of computational antitrust. I think it does cover those processes in relation to how do you make things easier, how do you make things more efficient, and that really spans, if you like, the gamut of work that can occur, you know, in terms of that pre-horizon scanning from a regulatory perspective, that horizon scanning, how do you, that detection. It also spans the actual investigation, you know, how do you make that investigation easier? How do you, if you like, ingest such large amounts of data in speed that you wouldn't normally, would normally take you such a long period of time, such that you can actually shorten an investigative process. And then it also, I think, spans like that decision-making process. So in an administrative system where you are writing the decision, how you can use those tools to help with that writing, that, if you like, summarization of the data and also the evidence that is before you. So those tools, I think it is a sort of a tools based analysis. In respect of other areas, computational antitrust, I think it's also understanding the evidence that is before you, in all that you have, all that is being used to, if you like, put that lens to appreciate the conduct which you need to apply an analysis to. So it's all of those things from my perspective, which spans, if you like, a life cycle of a case from a regulator. Thank you.
Thank you, Winnie. I think we will have a little bit more time to expand on your answers in a minute. And thank you very much for that. I think we can continue with Vasimakis and then with Sophia, your general thoughts about what computational antitrust is.
Hi, I hope you can hear me? Okay, very good. So, I mean, I am familiar, obviously, with the term computational antitrust, also because, you know, I'm a follower of Thibault, so Thibault has written quite a lot on these topics. Now, in terms of our kind of practical experience in dealing with these new issues, and not so new actually sometimes. First of all, I would like to make a distinction between, in terms of what we're talking about, I'd like to make a distinction between like computational tools as a kind of tools that we use for the practice of law. That's one area, for example, or competition law dealing with questions where these tools obviously are used. I mean, I will start from the second. Obviously, when dealing with major merger cases or even behavioral cases, we are quite familiar with these tools, especially when it comes to merger control, for example. Developed competition authorities use them quite a lot. Maybe the lawyers themselves will not be so much dealing with these issues. Probably our economists will be using these tools, and they will have a dialogue with the European Commission, for example, on sets of data, etc., etc. But definitely they are used quite a lot. when it comes to cases, obviously, we have been dealing with major cases where data played a major role. You know, I mean, I remember in the Google shopping case, the European Commission was always saying, oh, we have dealt with X billion of whatever data on a particular topic to show a certain result, I mean, a certain outcome when it comes to a particular type of conduct. But so, you know, we deal with them every day. From a policy point of view, I think these tools, and in particular AI, are more interesting, let's say, in the area of agreements, of collusion, for example. I mean, when it comes to Article 101 in our European competition law, I think this is being discussed quite a lot. It's a major policy issue. It tests the boundaries of our law, for example. Where does human behavior stop? Where does conduct of undertaking stop, and where does AI start? And then what about some other rules that we have when it comes to Article 101, which is that you need to have an agreement, you need to have essentially a consensus built by at least two particular undertaking companies. So, you know, we have been discussing those questions quite a lot, and this is a tricky area, and I'm sure we will be led obviously by competition authorities and how they will be dealing with specific issues. We will see what the first case, when the first cases come. I mean, we have seen some cases where they raise certain issues, and the European Court of Justice even has given some first, let's say, I would say some first ideas as to how it is likely to be dealing with these issues, but we have never had a real case where the issue arose in its full colors, so to say. Now, when it comes to how we use these tools in private practice, personally, I'm doing mostly litigation. We don't use these tools a lot, obviously. You know, I mean, to the extent we are able to facilitate our lives in terms of case law research, etc., there is a gap there, and therefore I would welcome all initiatives. I was hearing before the ending of the previous panel, I'm sure there is a business case to be made in terms of making our lawyers' lives easier in terms of navigating through the world of case law, etc. I always envy the European Commission's legal service, which is doing all these cases. So in my kind of mind, I think they have a huge computer and they press buttons and they say, oh, I need a case law on this particular point. They press the button, that the whole thing comes out, because they've been doing that forever, right? I mean, we are quite active as a law firm, and I'm sure Christina also, but you know, we can't say that we have been doing all cases of competition law, whereas the legal service can say that. So when we are able to press buttons and get results like that, I really look forward to that day.
Thank you very much for that. And again, we'll expand more on the application of legal tools in your practice later on. Sophia, can you please give us your comments?
Sure, happy to. And first of all, thanks a lot for inviting me to be part of this panel. Really looking forward to today's discussion. And I think I can probably only reiterate what the others have already said. I must admit that, when I was first invited to this panel, I did look up at least how Thibault thinks about computational antitrust to know what I was getting myself into, because I have to say that at least how I thought about it was probably much more narrower than how you can define it, because I always thought that computational antitrust essentially refers to, more sophisticated tools that I particularly use to detect things like, bid rigging, collusion, price fixing agreements, those sorts of things. And I think it was either Winnie or Christina who put it quite nicely, that it's It's really about doing the work that we've always been doing, trying to answer the same questions, but doing it in a more sophisticated way, using the technology that is already available, in a way that also, speeds up the work that we're doing, maybe makes it more effective. And I think what that also means is that, the tools that are already available or the potential tools that exist, I mean, it's an incredibly broad range, and that are all trying to address different needs, trying to help respond to different questions. And then I think are also all open to very unique challenges, because I think the range of computational antitrust tools is just so broad. And yeah, I think as Marcus put it, it is about making lives easier, I think, for the regulators, for the companies, or more specifically in-house counsel like myself, for the lawyers advising them. I think there's a huge potential to make things a lot easier. But I also think there's still a lot of room to grow, and as Marcus was also saying, making these tools more widely available, having tools that fill gaps where currently these tools don't exist or don't exist as widely.
Having a little bit of issues with the internet, but I almost heard everything you said. And I would like to use something you said that about how computational tools are making our lives easier. So I would like to move on to the next part of the panel and ask Winnie, what are those tools that are making your life and your team's lives easier at the Commission in Singapore? And then I'll just ask some small follow-up questions to that. And these questions are, why did you choose those tools instead of other tools? And I am also curious about the particular tasks that you are automating with the antitrust legal analysis and other procedures that you're dealing with, like in investigations, in analyzing cases, in conducting and supervising investigations, and maybe in assessing mergers.
Thanks, Maria. I should say that this is from my own personal perspective as to how I think it helps in terms of our cases from my experience, and not my organisation's. So I think there are a couple of tools that we use, and their purposes and functions do differ. So I talked about that horizon scanning, the life cycle. So from the very outset, we have a bid rigging detection tool that we use. So I think that's possible because in Singapore, all public procurement is done through one portal. And this portal requires those who are bidding for a particular tender to fill out these standardized fields and then submit their tender bids. And in filling out those standardized fields, one of those fields is price. And in respect of this portal, it provides, if you like, a very rich data source. And you can see some, just from my description, that structured data. So in relation to our bid rigging detection tool, it uses quantitative indicators, which are related to common signs of bid rigging, given that there are certain patterns that can be associated with bid rigging. And these indicators measure central tendencies and dispersion of that bidding data. So that's one tool that we can use. And how does this work in practice? If you like, I mean, this database was always available, but it would mean that officers would have to go through vast quantities of data, pull it out into Excel sheets. Obviously, with this automation using the bid rigging detection tool, you can do that process much more quickly and efficiently. It also, human error can occur, and so it, if you like, means that hopefully where it solves that issue. So that's just one tool. Another tool that we have is a document similarity tool. So as you know, with tender bids, tenderers that are in collusion may very well use similar phrases, similar terms. And this document similarity tool allows us to detect the similarities between tender documents that are submitted. And again, this could be indicative of bid rigging. again, these are tools. It doesn't mean that there is bid rigging that is occurring. It just means that these are flags for us to perhaps take a closer look at. I mean, this tool was developed with the Singapore government, GovTech, Singapore government technology agencies, which has helped us in respect of this particular tool. The other tool that I mentioned was developed in-house by ourselves. I mentioned mergers, and and I go more to an administrative process. So we've got a DocGen tool. So as regulators and as parties would know, confidentiality is an important aspect of any information that we collect. Obviously, we have to ensure that confidential information isn't disclosed inadvertently to any party or the public in relation to our decisions. So when when we have a proposed infringement decision or an SO in EU terms, you've got a number of parties. Each party's claim confidentiality over their documentation, but it could be correspondence between two parties, in which case it won't be confidential to those two parties because they were involved in that conversation, but it will be confidential in respect of other parties who may not have been aware of that conversation. And so this document generation tool allows us, if you like, on a master document to isolate which parts are confidential and which ones aren't. And then we can then, from that, using that tool, generate the different versions of the decision or proposed decision in a merger case, in a cartel case, in an abuse of dominance case, which we can then surface to the parties for representations or for the final public decision, depending on which stage we're at. So that's, if you like, one administrative saving in terms of time. One more tool, let me just mention quickly, is our online mergers filing portal. So again, we've as a push in terms of digitalization, which spans our work and is a critical plank of what we're looking at to do in-house, is for mergers that used to be filed like sort of like a portal through email, and people would email their submissions in. This portal has set fields. Those fields need to be filled out. Then a link is provided where more detailed submissions, which are not standardized, are uploaded. But this means that we can, using automated bots, take the information that is filed and bring it in-house into our own systems, in which case we can do data analytics around that. How many sole applications, how many joint applications, in which jurisdictions, are these international mergers, are these domestic mergers, and also, who are the key parties, so that eventually we may be able to automate, sending out of letters to third parties that are nominated in the forms that are filled out, in the key fields that are filled out. So they're just some, if you like, a quick snapshot of some of the tools that we've used. I mean, we also have an e-statement tool that's in progress, and a complaints management tool in progress as well. But they are, if you like, yet to be launched, but something that we are working on right now.
I wanted to follow up and ask if you have been engaging in cooperation efforts with other antitrust agencies, and if you have been sharing these tools. But I'm just gonna let you answer to that question in the end, because I know we have time constraints, and I'm gonna ask Christina, Simakis, and Sophia, just in 2 minutes of their opinion, what tools have you been using in your work? And what have you found to be the right task in antitrust for technology to jump in?
Well, I think the first thing I need to do is to get together with Makis and find that secret machine in the legal service, because then we're going to have a killer product that all our clients will love. I agree. I don't have faith that that their cases have been, or their case experiences have been automated, but it's a good idea. No, jokes aside. So maybe quickly 3 areas where we kind of use these kinds of tools with clients. I mean, one very obvious one, of course, is large doc review in kind of defending investigations and the mergers in the various different contexts. I mean, we're as you know, Winnie and other regulators are, we're dealing with enormous amounts of production of documents and emails and all sorts of communications, and it's it's a new world that's sometimes quite challenging, and we have various tools to do that in-house and external. And maybe just a few comments more from a kind of law firm perspective, working with clients. I mean, one thing, of course, we have to kind of balance the need to obviously make full disclosure with the risk of kind of making errors or omissions when we use various technical tools. And maybe a couple of comments. I mean, one comment, I think, Marie, in some of your questions, you were kind of saying, how do you use this if clients use these tools? I mean, one comment I would make from my experience, in particular in the EU, is that we often work very closely with clients, and one reason for that actually is legal privilege, to be honest. A lot of this is very sensitive, and in the EU, in-house counsel don't have legal privilege, and so we it's not that the clients kind of give us the results of the searches or that we just use tools, but we work very closely with clients in these kinds of discovery and document production projects, and there are various challenges, including how do you secure, if you use these tools and various automated decision making, how do you secure kind of an audit trail? How do you know exactly what's been produced and what's not been produced when you're not kind of reviewing things manually? That's sometimes a challenge. And I think one thing that I've seen, which again is something we've always done. I mean, we, in the past when we were dealing with more simple discovery, we kind of negotiate with the European Commission, DG Com, for example, on who are the what do you call it, the relevant people in the company, in the client, who what are the relevant search terms. We've always had those kinds of negotiations and discussions with when we're responding to, for example, Commission RFIs. But I think those kinds of things in this new world are more complicated, and going back to securing the audit trail, I think one maybe good practice is to really make sure that you have conversations with the regulator. What exactly are you doing? How exactly are your tools working? What exactly are you producing, not producing? And what exactly are the search terms or the relevant, criteria? Because that, I think, might reduce the risk of potentially, getting into trouble for having, omitted something. So I think we just need to understand, part of our challenge as law firm lawyers is to really understand what are we doing and how does this all work, to be able to make sure we try to protect our clients as best we can. If we miss something or something goes wrong in those kinds of, large discovery or document production exercises. And one point that is maybe interesting, I think we're in a very different position from the regulator. I mean, Winnie and other regulators, if they're using tools to discover evidence of potential cartel or bid rigging or illegal behavior, if they miss something, is not the same risk, because you're looking for evidence, right? But for us, if we defend and miss something, we can get our clients into serious trouble. So I think maybe there's a different dynamic. We have to be very careful about, again, explaining exactly what we're doing and how we're using the tools, and trying to protect ourselves, against any risks with the regulators. Maybe quickly, another area that I've seen the use of kind of automated tools is, of course, compliance. And I won't go into too much detail because of time constraints, but different clients, of course, have different compliance tools and programs, and a lot of that these days is online. You can have different prompts, you can have different tools that review, for example, in financial services and banking, communications. You can review large sets of communications and have flags for different kind of antitrust risk indicators. So that, I think, is an interesting area. Make sure you design questionnaires. Those can be linked to certain business processes or prompts, and identifying different areas of risks that can somehow be automated in terms of flags, compliance flags. and then maybe thirdly and finally, another interesting area I think is remedies, and you know, being someone who works a lot with kind of in the tech world and big tech platforms, etc., those kinds of investigations. I mean, I think that's fascinating. I mean, how do we design remedies? How do we convince regulators that, you know, whatever remedies we're proposing are effective and efficient? You know, for example, if we're looking at, you know, choice screens or you know, consumer choice architecture and how to design whatever different you know, marketplaces or rankings or web pages or search tools. I mean, it's very interesting because, as we all know, and you know, I've heard Susan Athey and others speak brilliantly to this. You know, it's you know, regulators are becoming increasingly sophisticated in terms of understanding that consumers don't just, you know, easily click or easily go to the third page of the search results necessarily. So, you know, understanding, you know, consumer behavior and behavioral economics, understanding, you know, computer science, data science, and trying to then, in our role, show, you know, what is an efficient remedy, what has the desired effect, you know, how do consumers behave in the online world in particular. And this, you know, links interestingly to the new regs that we're now seeing, the DMA, for example, in the EU, you know, where you talk about effective compliance, you know, in terms of various practices that are covered by that regulation. And how do you show that? I think a lot of it will have to do with these kinds of areas, showing that consumers will, you know, it will be effective in terms of consumer behavior or online, you know, product design or choice. Anyway, I'll maybe leave it there, but it's a lot of interesting areas where tools are relevant in our private practice with clients.
And I'm going to pick up exactly that, what you just said, and ask Makis just briefly, and then move on to Sophia, because I have a very interesting question I'm very curious to ask you about. Makis, how does agency use of computational tools change your work as private practitioners? Just to follow up on what Christina just said.
Well, I mean, I would say they make our lives more difficult, but that's not the correct answer, the politically correct answer. No, I mean, to be fair, we want the competition authorities to be very much modern when it comes to the way they work. These tools are very important, you know, because essentially they allow the competition authorities to work better through the facts. This is what, at the end of the day, a competition lawyer wants, the competition authority to take proper account of the facts of a particular case. So everything they do there, I mean, is welcome. And in fact, if you see now in the competition authorities, certainly the European Commission, there's, if you go to their organigram, it's a word we use to look at the way the authority is structured internally, you will see that a very senior position is called the Chief Technology Officer. For example, the European Commission, the DG Competition, has a Chief Technology Officer. Currently, the position is vacant, but soon there will be somebody filling it in. So, and other authorities, to other agencies, to have this kind of chief technology officer. So this is something definitely that is very much adopted by competition authorities, and we are looking to these developments with a lot of interest. Now, from what Winnie was explaining, for me, the important point in history will be when these kinds of assessments become a proof in themselves. Because from what I see, I mean, I can see technology being a tool in terms of uncovering evidence or systematizing evidence, etc. But the evidence to build a case, the tool cannot give you that evidence. The tool itself cannot be the evidence, right? You cannot go to court and say, AI has told me, and it has to be true because it's unmistaken in this particular case. There's no error. AI is telling me that there is a cartel here, or that there is collusion, for example. there's a concerted practice. That cannot stand in court. So when we cross that bridge, then of course we would be in a totally different and new world. I mean, when these types of tools will be used as evidence in themselves.
Thank you. That's a very provocative thought. I would love to give time to Winnie to answer and to respond to that. But I'm going to go to Sophia and ask her a question about how is Google's legal team using Google's APIs and technological developments? And how are you integrating them into your legal analysis? I think it's very interesting that you are right there in the middle of technological breakthroughs. And I think we all want to know if you're taking advantage of all of that technological advancement in your legal analysis and how you're doing that. And then we'll go back if we have time.
I mean, it's a very good question. And I think it's safe to say we probably could be using these tools more because I think like anybody who looks at these tools and anybody who works in competition law, I think is aware of the various challenges. I think Marcus was just touching upon the fact that, you still need humans to sort of, I think that's what he was getting at, that you still need humans to sort of evaluate what the tool spit out. The tool itself is, not yet the evidence or not yet the answer. I think Winnie was touching upon the fact that, data availability is a challenge. And I think as a company, we're not immune to these challenges. I think we are, maybe somewhat uniquely placed because we have access to a lot of tools, and maybe we're more prepared to develop these tools. But as I think I also said in the beginning, I think the range of tools that are available or that could exist is impressive. But it also means that you just have a lot of sort of different questions that you're trying to answer that require bespoke tools. And so, to respond to your question more directly, I think we're probably not using these tools as much as we maybe could. But just to give a few examples, and this might be pushing the boundaries of the definition of computational antitrust tools somewhat, but at the very basic and the really not very sophisticated tools, we have, on the one hand, a repository where we upload our submissions to regulators. And the purpose of that tool is really to help us respond to future RFIs, to make that work quicker, more efficient, to ensure consistency. But it also allows us, to search the tool to see where we're seeing trends, regulators in different fields asking about the same products, asking the same types of questions. So that's really helpful in terms of analysis and sort of sharing insights internally as well. Then secondly, we have a tool, and again, it's not super sophisticated, but it does save us a lot of time, that helps us automate part of the RFI response process and actually automating sending out emails to internal folks. Because I think what we saw a few years ago was just RFIs getting increasingly lengthy and increasingly complex in terms of the number of products they cover, the sheer number of questions in an RFI. And so as in-house counsel, we found ourselves just having to write, sometimes hundreds of emails, just following up with folks internally. And, then you're not liaising with the right person because somebody has moved on, they've changed position, and then you have to do the same thing again with somebody else. And then you have to chase for input. And so with one of the law firms we work with, we came up with a tool that actually automated part of that process. And so it's probably not what you think about when you think about computational antitrust, but I think it still fits the definition because it saves us a lot of time. Because I think that is also one of the purposes of computational antitrust tools to some degree, right? That it can automate things that can be automated. And so that you can then focus on the work that cannot yet be automated or where you haven't yet found a solution for how to automate it. I think at the other end of the spectrum, and Christina was touching upon that, is, we do have tools that help us implement our remedies. And to some degree, these tools are based on existing frameworks we already have and based on existing software. I think we're very lucky in that regard. But again, I think one of the limitations is that these are very bespoke tools, uniquely developed for one specific case to address one specific problem. So the next time you're looking at a new case, you sort of, have to come up with a new tool that helps you implement the remedy for that case.
Thank you for that. I think we're almost reaching the end of the panel, and I just want to ask each of you in 2 minutes if you can give us some final thoughts, and also quickly ask how you are keeping up with technological developments and how you're planning to incorporate that into your practice. Christina, we can start with you. Thank you.
Thank you very much. I'll be quick. I mean, maybe one point to make is that you know, we as law firms, and Sophia just mentioned an example. I mean, we as law firms are also developing these tools. I mean, A&O is very much at the forefront of AI. I mean, we have our own lovely Harvey, which is our own internal kind of AI tool, you know, which is kind of, you know, increasingly used in various interesting ways. I've asked it to do various presentations and kind of, you know, short kind of summary memos, whatever, or case law research. I mean, I have to say, though, I very much agree with Marcus's point and point others have made. You know, you still need the experts, you still need the lawyers. I mean, we've all read these examples of you know, litigation legal briefs with made up case law. I mean, I for example, recently asked it, can you know, do a short speech for me on the DMA? And, you know, part of it clearly was referring to the DSA, you know. So, I mean, it's, you know, it's obviously not perfect, but I think as a way of getting a first product, as a way of getting some ideas, you know, as a way of dealing with, you know, some kind of contractual clauses and you know, standard contracts and, you know, various versions of buyer-friendly, seller-friendly. I mean, there are lots of very useful applications, and we're you know, we're very much investing in AI also as a firm. Maybe a second point, and this is the question you asked, Makis. I mean, I do think, both in terms of investing in tools and trying to learn to use those tools in an intelligent way that benefits us and our clients, you know, I do think also we as lawyers have a new challenge in trying to, you know, be interdisciplinary. I mean, it used to be that we, you know, we needed to understand economics as antitrust lawyers, and that's part of what I've always loved with this area of practice. But, you know, I do think now we need to kind of also try to understand computer and data scientists, and you know, we hear all the agencies recruiting, you know, new kinds of expertise. I think the question was asked yesterday, you know, could a competition agency ever be led by a computer scientist, and why not? You know, so I do think we're challenged, you know, but by needing to understand kind of new areas of expertise. And I think it kind of adds, I don't know if Marcus agrees with this, but I think it adds a bit of a new layer to our job, because we don't only need to kind of review the evidence and the data and the whatever communications and kind of apply, you know, the legal test to the evidence, but I think we also need to understand a little bit these tools, as I was mentioning earlier. I mean, how has the automated decision making happened? What criteria were used? What selection, you know, terms, whatever, because we also need to, you know, defend in terms of, you know, is there bias there? Is there something that disadvantages our client? Is there something that gives the agency the wrong, you know, result in terms of evidence of illegal behavior? So I won't go on for too long, but I think there's a kind of an additional layer of being able to understand the tools and understand, you know, what we might need to argue and advocate to agencies on behalf of our clients if those tools aren't, you know, providing the right results. So I'll leave it there. Thank you very much. This has been a fantastic discussion.
Maria is probably locked outside of the network, but Winnie, I'm actually also curious. She referred back to you quite a few times to hear your thoughts on what you heard on the panel.
So I think what, in terms of looking forward, what we're doing, we've just set up a new data and digital division within the organization, pulling, if you like, officers from other divisions to that new division, as well as recruiting you know, a data scientist or a data engineer to assist us with our work in this area. And so also there is a number of sort of training programs that we're encouraging officers to go on to ensure that we are, if you like, kept up to speed and learn the language in relation to data, as well as how we can operationalize more effectively our tools to help our work. And so that's, if you like, on the sort of technical internal side. In response to some of the sort of queries, you know, I think one query was related to other agencies. You know, to what extent do we speak to other agencies? I think there's a lot of dialogue that's going on at the moment in respect of this area with at forums like the ICN, at side meetings, and also in respect of capacity building. So there is a lot of dialogue, and I think we're keen to learn from other regulators what they're doing, and see how what they're doing may translate to your own jurisdiction, given, you know, you have to have a primary source, like, you know, for us, we have that public procurement portal. I think another question, and then just briefly, was how do you, or, you know, do you always need a human, if you like, associated with that analysis? And yes, I mean, certainly in relation to evaluating that evidence and coming to the conclusion as to whether the conduct is or is not anti-competitive, requires a degree of judgment. I think where I spoke in respect of, you know, evidence review is that sometimes the conduct may actually be facilitated by an algorithm, by computational tools for the conduct itself. And I think it's there that, you know, it may be helpful, or we may see other tools being used to, if you like, understand those tools, or to get explanations from a company as to how they're using those tools. And, you know, because what we will see is the results of the use of the tools, and then we want to understand how those tools operate, and then, if you like, to evaluate or give some context to the conduct that we, or the outcome that we see following it. So that was my comment about, you know, ensuring that we have an appropriate lens, and that appropriate lens may need us to be more proficient in respect of algorithms or other tools that look at the data or computational aspects. I'll leave it there. Thank you.
Thank you for the explanation. Makis, the floor is yours for some concluding remarks.
Yeah, just very quickly, I mean, on whether we need people with which are conversant when it comes to computational tools. Absolutely. I mean, up until a couple of months ago, I was also responsible for our recruitment, for example. So I would definitely look with a lot of interest, you know, at the CVs when there was this kind of, oh, I have studied also computer science, and so definitely I was quite interested in those multidisciplinary, let's say, CVs. I wanted also to share my own experience. I have been working in this area for 20 years. I mean, the first case I was involved 20 years ago was the Microsoft case, the first Microsoft case before the European Commission. The Microsoft case, and in fact, the decision of the Commission, owes a lot to one particular person in the Commission's legal team. And now time has passed, we can give names. His name is Jean Ubu. He was a French guy on secondment from France. If you ask me from the other side, which was the most critical, let's say, part of the team of the Commission back then, it was Jean Ubu. That's clear. Why? Because he was an expert in computer science and economics. He was not a lawyer, not a pure IO economist, but he was somebody that could really understand the facts well, and he could translate also the facts, because to understand the facts is one thing, but you need to have the other foot, let's say, on the other side, and you can translate the facts to lawyers and economists. So this is very important. And how I keep in touch with technological developments. Well, I mean, I'm based in Brussels, and the agencies that I work with, they tend to be like the first to shoot when it comes to this type of new phenomena. You're all aware with the Brussels effect. I mean, certainly the European legislator is very active when it comes to this area. I mean, only a couple of days ago, we had a political agreement on the Artificial Intelligence Act, and there will be some enforcement powers also with the European Commission. So, you know, we have the authorities here are quite active, so we have to keep track with everything that happens in this area. Thanks a lot for the invitation.
to some degree, I don't know if you saw that, but the French President Macron announced that he wasn't too pleased with the act. So might it be the end of the Brussels effect? We'll see. But Sophia, the floor is yours for some concluding remarks.
Yeah, I guess I have to agree with Marcus that you have no choice but to keep up to date with all of these developments. But I do think it's a really exciting area. I think some of the challenges we touched upon today, they will not go away anytime soon. Access to data, access to also, high quality data, and having the right tools to actually work with that, but also having humans involved in evaluating that. I think all of that will not go away, but I do think there's a lot of opportunity to use more of these tools. And I'm really interested to see, what additional developments we'll see over the coming years, because I do believe that it has the potential to make lives easier for regulators, for lawyers, for in-house counsel. So I think it's a really exciting space.
All right. Yeah. On that note, thank you so much. I think it was a great addition to the conference. You added a lot of talking points that we did not even touch upon in the last couple of days.